with item number 20, case number 3744952, Lucius Conway versus Warren Evans.
Good morning, Your Honors, and may it please the court. I want to first explain that my covering is part of me as a Tiwahito monk and Ethiopian tradition.
Okay.
Okay.
Before you begin, let me make sure we have everyone here. What's your name?
Lucius Conway.
You're Lucius Conway. Okay, welcome to the court. We also have counsel for the defendant Appellate appearing remotely, I believe.
Yeah.
Okay. So Mr. Conway, I don't know if you were here when we began, but I always just remind everybody, and I'll do the same again with you. We have read everything that you filed. We're very familiar with your arguments and the facts of your case, so you can keep that in mind. You don't really need to start from the beginning and tell us what your case is about. You can kind of jump right in and tell us, you know, why you think you should prevail on this and what your best arguments are, whatever you want to raise today in addition to what you filed in your briefs. Okay?
Yes, Your Honor.
All right.
Thank you so much.
You may proceed.
Thank you. I'd like to reserve 10 minutes for rebuttal for each of the defendants, if I may.
You get 10, well, you get up to 30 minutes total.
Okay, well, I want to reserve 10 minutes so I can rebut each of them.
Then you
5 minutes each.
Okay.
Okay, but this is not going to take anywhere near
Okay.
20
Usually
minutes.
doesn't.
Okay.
All right.
So we're here today on the fundamental question of whether or not a trial court may defeat its own subject matter jurisdiction by disregarding good faith allegations of damages that, on the face of the complaint, meet Michigan's statutory threshold for circuit court jurisdiction. It is the appellant's position, consistent with Hodge versus State Farm, independent tort claims. The court must evaluate each claim. So the binding precedent in Michigan states that where a complaint pleads both contract and independent tort claims, the court must evaluate each claim separately and give effect to the damages pleaded in good faith rather than subsuming tort claims into a contract theory or artificially limiting the amount in controversy. Any contrary approach misapplies Michigan law and constitutes reversible error. I therefore respectfully ask this court to reverse the dismissal and remand with instructions that the trial court recognize its subject matter jurisdiction and proceed to adjudicate each pleaded claim independently on the merits.
Right.
No questions?
No questions right now.
Very
Thank you very
good.
much.
Thank you.
So we have two defendants present, one remotely. Who's going to go first?
Jacob, is it all right if I go?
You said you want to go first?
Sure.
That's fine with me.
Morning, Your Honors. May it please the court. Zachary Matzo on behalf of Wayne County and the individually named Wayne County defendants. This case is a simple matter involving an agreement to arbitrate. That was the motion for summary disposition that was filed. That was the motion for summary disposition that was granted. And Wayne County remains ready, willing, and able to arbitrate pursuant to the settlement agreement that both Wayne County and the appellant signed in this matter. Pursuant to 2.116C7, the lower court was well within its right to grant summary disposition based upon the existence of an arbitration agreement. Paragraph 9 of the settlement agreement that the appellant and the county and the union were party to, subject to Mr. Conway's separation of employment, states that if a dispute arises as to the enforcement or interpretation of this agreement, said dispute shall be resolved through the grievance and arbitration process set forth in the CBA between the employer and the union. That's appellant's appendix C at page 18. There's no dispute that the appellant, the union, and Wayne County are signatory to the agreement. And there's no dispute that this is 100% rooted in the amount paid to the appellant pursuant to that settlement agreement. And honestly, Your Honor, based upon your statement prior, I don't really have anything to add at this point. I'd be happy to answer any questions if you do have them.
I would just ask this, I guess I think the arbitration issue was an alternative grounds that the trial court gave. And the first grounds had to do with subject matter jurisdiction. Do you have anything you want to add?
Absolutely.
Okay.
While I respect the trial court's ability to make decisions on their cases before them, I think it was handled in an unfortunate manner, as the argument made in our summary disposition in motion in lieu of an answer focused on the settlement agreement issue, and the amount in controversy issue was not something that we brought to the forefront. That happened independently, and it was addressed first in the opinion. Personally, I believe that the amount in controversy issue is secondary to the existence of the valid arbitration agreement, and the valid arbitration agreement is enough to have the case removed, and it's enough to have the motion granted.
What, do you think the trial court was wrong then?
Do I think the trial court was wrong? I do not.
Subject matter jurisdiction?
I do not think the trial court was wrong. I don't think that that is the primary grounds to have the motion granted. If you'd like, I can walk you through the math, but assuming you guys are like me and became attorneys to avoid math, I will not do that. But essentially, we're talking about a difference in interpretation of $5,412.08. I don't think that it's in dispute that that number, regardless of what appellant may believe his actual damages are or anything like that, that number is in fact below the statutory jurisdiction amount. Sufficient?
Yep.
Thank you all.
Thank you very much. Counsel?
Thank you, Your Honors. I echo the sentiments of counsel.
I'm sorry, you're Mr. Pocarelli, is that right?
Yes, Your Honor.
Okay, just wanted your appearance.
Oh, I'm sorry. Yes. Jacob Porcarelli on behalf of AFSCME Local 1659, the individual union defendants as well, who are now union appellees. Like I was saying, I echo the sentiments of counsel from Wayne County. With this particular issue, we filed concurrent motions for summary disposition. The subject matter jurisdiction argument was put forth by the union. But ultimately, the judge also found that both defendants in this instance, so both appellees, were entitled to summary disposition pursuant to C7 because the arbitration agreement applied to all of us. Appellant's biggest argument is that the union allegedly waived arbitration, and that's why he's permitted to proceed in court somehow. But that burden is on him, and he has failed to meet it. The evidence put forth in his brief does not demonstrate that arbitration was waived, and the remaining claims that he has fail as a matter of law. So I know he's upset that the motion for what he referred to as a motion for partial summary judgment that was brought under C9 and C10 was dismissed, but neither of the appellees brought forth answers. They were motions, so those do not count as pleadings under court rules and case law. And so that was procedurally improper. And then, his other motion or his other arguments in the motions that there was no genuine issue of material fact, like counsel from Wayne County aptly put in their brief, it's premature, but also, just as a matter of substance, it does fail. An IIED claim cannot be rooted in a contract breach, and the civil conspiracy has to have an underlying tort, and contract breach is not that as well. So for all of those reasons, the trial court's decision should be affirmed.
Thank you. Any questions? Thank you very much. Mr. Conway, you have time for rebuttal.
Thank you so much. Okay, so first, I would like to state that whereas counsel for the county indicated paragraph 9 of the settlement agreement should rule or control with the arbitration clause therein. However, that falls under the illusory remedy doctrine. As the papers show, there has never been any arbitration procedure post-employment by the union. Therefore, there is no process by which arbitration can take place. The union indicated, and evidence was provided from the union president indicating that they had never done it. In conversations with union representative at the state level, they further indicated, and it's in the record as evidence, that this has never happened. And in order for a procedure to be instituted, it would have to go through a number of hoops in order for that to happen. What indicates the union's non-willingness and thus constructive waiver of arbitration is the email from the president indicating that they were done with the issue and would not revisit it. The subsequent claims with regard to the subject matter jurisdictional issue, which the judge agreed with counsel by limiting it to what they believed the contract would yield. However, we have two tort claims that must be under Michigan law separated and determined on their own merits, which both indicate that the amount in controversy would be above and beyond $25,000. And where they want to predicate those tort claims on the contract breach, the complaint on its face in and of itself clearly indicates it is not based on the breach. It is based on the conduct of the defendants after the breach and that impact on me as the plaintiff in this particular case. So we're not talking about something, a conspiracy that resulted from breach. We're not talking about IIED that resulted from breach. We're talking about that behavior that occurred after, post-breach. When I tried to contact them, nobody responded. And the record will reflect that the only time that either the county or the union responded was after I filed suit. And they then let me know, the union let me know in writing, we don't have a post settlement process for arbitration. So we wouldn't be doing that. However, as the county pointed out in paragraph 9, the collective bargaining agreement indicates that this arbitration procedure has to follow the CBA. There is no post-arbitration procedure in the CBA, which makes it fall under the illusory remedy doctrine. There's no remedy available, which is why I had to go to court. I believe, in conclusion, based on the fact that the court did dismiss by subsuming the tort issues into the contract issue without actually taking the complaint for as true as the law indicates they should have, and dismissing the case without even considering the merits. And with that, I'd like to thank the court for its time.
Thank you, Mr. Conway. Appreciate your being here and your arguments today and your briefs as well.
Thank you.
And what we will do from here, just so you know, is we will, we've been studying your case, but we'll continue to do that and make a decision as soon as we can and issue a written opinion.
Thank you.
All right. Thank you all.
Thank you.
Case is submitted.